Good morning, Council. Have your seat. This one is set to connect. That's my phone. Council, you can remove your wig and gown if you so wish. We have virtual sitting, so we'll start with the virtual sitting. Where are the lowest? In both. Huh? Have they gone there? Have they gone to the? We should go to that link because maybe I don't know if because of the echo it may. And if there is no challenges with the echo, we can still. Why in the witness? Then let them see that is where they are.
You connect.
Yes, I will connect now.
Please connect. Tell them to connect. Okay, that one's there.
Yeah, the ones there.
Okay.
Yes.
Yes, for the virtual hearing.
We are ready. We are ready. Please connect. Please connect very fast.
Hello, good morning. What is ready to start sitting now?
As the court visits.
Call the case.
Resume today, Thursday, the 20th of May, 2022, before His Lordship Justice Sanusi Kanu presiding. Suit number NICN 888-2020 between Bryce and one high quality baby limit. 2, Helena Caroline. 3, Isabel Ann. 4, Engineer Ben Aka. And present. Absent.
The defendants are present. They are present virtually.
Well, let them mention their names one by
Please
one.
mention your names one by one. I'm trying to connect.
I'm Helena Caroline Appio.
Okay.
I
You are
am.
welcome.
Is Helena Caroline Appio, sir?
Yes. The second person.
The second
What's
party,
your name?
please.
I am Isabel Ann Appio.
The second party is Isabel Ann Appio.
They are second and third defendants.
They are second and third defendant, my lord.
Appearance.
Yes, my lord.
Yes. Your name is?
Manga. I am the claimant on record and I appear in person.
You know you can't appear in person and be robbed. You can't appear robbed before the court if you are appearing for yourself. You either choose counsel to appear for you, or you decide if you want to appear, then you won't be robbed. You have privilege staying at the bar when somebody is, when you are, if you are not represented, you will have the privilege of staying there, but you don't have the privilege of wearing your wig and gown. Raymond Manga, you are appearing for yourself?
Yes, my Lord. I'm appearing for myself. My Lord,
You can't appear with anybody.
that's why I say my Lord.
You can't appear. That is not the rule. It's not allowed. You either choose to be represented by a council or you represent yourself. If you are representing yourself, you can't appear. You are not appearing as a lawyer. You are appearing as claimant, the party in the matter.
My Lord, yeah. I say my Lord. That's why.
I said it's not allowed. You can't appear with any other lawyer. You are appearing as a party. If you are appearing as a party, you can't announce your appearance and appear with somebody.
As the court pleases.
I appear in person as Raymond Manga.
I have recorded you. Yes.
Okay. It's for the first respondent, the first and fourth defendant. No, to announce. He has joined on Zoom, sir. The first and fourth.
Announce your appearance, counsel.
Mr. Oduga Wama.
Odugadi, make yourself and announce your appearance. Mr. Odugadi, make yourself visible and announce your appearance. Let's go ahead.
Okay. With profound humility to proceed. My name is,
Sit down.
as the court pleases, my name is Ohimai Obuse. If it pleases the court, Ohimai is O-H-I-M-A-I.
Yes.
Obuse, O-V-D-I-O-I-S-E.
Yes.
I am with my colleagues.
Are you appearing?
I want to mention the name. I am appearing for the second and third defendants.
Appearing
with my colleagues, Okpeoluwa Sango Saya.
Yes.
Ukeme Johnson.
Yes.
And Esther Adebetu.
Esther Adebetu.
Yes, sir, my lord. We are most grateful, sir.
Yes. This matter is for defense.
Yes, my lord. It's for defense, and we are ready to be subject to the convenience of the court.
Where is the witness? Is the witness that is
okay. The witness is Isabel. Isabel and Appeal, please answer.
Yes.
Yes. The witness is ready to be sworn, my lord.
Registrar, administer also on the witness. Registrar, administer also on the witness.
Yes.
Witness, are you a Christian or a Muslim?
Sorry.
Are you a Christian or a Muslim?
Oh, I'm Christian.
You don't want to swear with the Holy Bible or you want to affirm?
The Holy Bible.
Okay.
Let's come to raise our hand to mention it.
Lift up the Holy Bible.
So please raise your hand.
Raise your hand. Stand before me. I swear. Put in your name there. Insert your name. I. Put your name there.
I, Isabel Ann Apio.
Do swear in the name of the Almighty God.
Do swear in the name of the Almighty God.
That the evidence I shall give in this case
that the evidence I give,
I shall give in this case
the evidence I give in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
nothing but the truth.
and nothing but the truth. So help me God.
Yes, Counsel.
My name,
Yes. You are
sorry,
name
pardon. Oh, my name is Isabel Ann Apio.
and appeal. Yes.
Your address?
Is Indigo Muse, London.
Please come again. Your address.
Oh, Indigo Muse, London.
Yes.
What do you do for a living?
Pardon?
What do you do for a living?
Did you, what am I, sorry, it's broken up. What?
What work are you doing?
Oh, I'm retired. I'm retired.
Yes, you are retired.
Yes.
Please witness, do you remember the positive written statement from court on the 30th of July 2021?
Sorry, I can't hear the question.
The question is asking you is, can you remember making statement before the court?
Yes. Yeah. Could you repeat the question, please? Yes.
Yes. Mr. Manga, any cross examination?
Yes, my lord. Now, may I have the evidence?
Your lawyer said he has finished asking you questions. Now, the claimant who brought you to court is going to ask you questions concerning what you have stated in your witness statement on oath. When he asks you, you give the answer, because I'm going to record whatever you said. You can sit down, no need of standing. Sit down, don't break the protocol, because we have to see you. Your face is not showing. This thing is being recorded. So your face should show. Yes, you can go ahead.
In the written position that you just adopted, it shows the call that you say in number 1 and pass to Canada. That's true.
Please unmute your mic.
Mr. You have muted your, put on your microphone. You have muted the speaker. She can't hear you. Go on, unmute. Okay.
Can you hear me now?
Yes.
Yes, the question I asked is, in the written deposition which you just adopted before this court, You told the court that you reside in number 1, Efangangpa, Calabar, Cross River State. That's true.
Well, I live in London.
Yes.
Yes, it is not in dispute that I, the claimant, was engaged by the first defendant, that's High Quality Bakery, as a company secretary and legal advisor via a service agreement, which is Exhibit A in this court.
Yes, Isabel, what do you have to say?
Yes, he was employed by High Quality Bakery.
All right.
Yes.
Now that service agreement, Exhibit A, was signed by you and the first defendant, that is Helena Apio, as directors and agents of the first defendant.
We were directors of High Quality Bakery.
Yes, I said it was signed as, you signed them as directors and agents of High Quality.
We signed as directors of High Quality Bakery, yes.
Good.
And who is the second person?
That's the second defendant.
You mentioned name. You did not say second defendant when you are asking her. So that's why I'm asking for the name.
Now the second defendant is Helena Caroline Apio.
Yes.
Yes, as directors of the first defendant, you and the second defendant, that's Helena Caroline Apio, acted for, on behalf of, and as agents of High Quality. That's true.
There is no need for that. She has already told the court that she signed on their behalf, on behalf of High Quality Bakery. So why repeat the question? Ask another question. She has answered that one. She has already said that she signed on behalf of High Quality Bakery. Yes.
Yes, on the 5th day of August, 2020, 5th day of August, 2020, you and the second defendant sold the first defendant, that is High Quality, to the fourth defendant, Ben Aka. That is true.
I know it was August 2020. I don't have the exact date in front of me.
You don't have the exact date in front of you.
It's August 20, yeah, August 2020. I don't have the exact day in front of me.
Yes.
On the 5th day of August 2020, you had signed a deed of assignment selling High Quality to the fourth defendant on the 5th day of August. That is true.
I will object.
Object to what?
I will object because the deed of assignment was being referred to, my lord, was not pleaded by the claimant. And it's not even before the court. If we agree, we have cross-examination, but the cross-examination will be within the ambit of the case and the cases of the parties as presented before the court. And not otherwise.
If it is relevant to the case he's making, if it's relevant, then it will be allowed. It's now for your address to point out the Yes.
Yes, I had asked you that on the 5th day of August 2020, you signed a deed of assignment, you and the second defendant, selling High Quality to the fourth defendant, Ben Akak.
I don't have the exact date in front of me. I believe it was August
What
2020.
I mean is, Sorry, on the 5th day of August, you had signed a deed of assignment selling that place. That is true.
Yes, we sold the bakery to Ben Akak. I don't have the exact date of the deed of assignment it was signed. I believe it was August 2020.
All right.
The bakery, high quality bakery, yes, we signed a deed of assignment to a new owner.
Yes.
When I show you the deed of assignment, you'll be able to remember the date.
Yes, is there any need when she has already admitted?
My lord,
She has admitted selling the
my lord, I have the deed. She said she has forgotten the date. I have the deed of assignment so that.
No need. She has admitted selling the bakery.
My lord, the date is important to me. I have the deed, intend to tender it. That 5th of August is important to me.
If you have, why did
my lord, it is.
When you are giving evidence.
My lord, this is evidence.
Yes.
It is her document, and I intend to tender it through her. This is the document. I don't know how to show her, my lord. Please show her the document.
Yeah, she will see.
All right, this is the document that you signed with Ben Akak. Can you see it?
I can't see it clearly, no.
You can't see it clearly.
I can see the document, but I can't see the words.
Okay, you can't see the words. I have brought it closer to you. Can you see the date that you signed the deed of assignment?
I can't see it, but I'm acknowledging that we signed a deed of assignment and we sold the bakery to Ben Akak.
Yes. I want to know the date you signed it. It is on the document. Can you see it? Since you can't remember.
I can't see the words. It's blurred. Maybe someone in the court could tell me. I don't know.
My lord, may I be guided in the circumstance? Because I intend to tender it so that the court can rely on the dates. It is her document.
Is there any dispute on it?
Yeah, my lord, they did.
You can tender it. I said,
Yes,
is there any dispute on it?
Yes, sir, there is.
Because she
It
doesn't
is her
have
document, and she has acknowledged it as her document. I intend to tender it to her as an exhibit in this court.
My lord, the documents to be tendered by the
complaint.
Yes.
First was not pleaded.
Yes.
To the extent that the document wasn't pleaded, the tender of the document is ambushing, an offense. An offense, the principle of natural justice.
Yes.
In that the defendants and their counsel on record.
Yes.
Yes, have not cited this document as part of justice in this suit until this morning in the course of these proceedings. My lord, the document is also in photocopy for which no foundation have been laid at all. As to the whereabouts of its original.
Yes.
But more so, the maker of this document, have not been brought to court for the purpose of admissibility of this document. and to afford the second and third defendants opportunity to cross-examine the maker on the veracity and authenticity, my lord, of this document, particularly its content.
Yes.
Not on the foregoing grounds object to the admissibility of the documents.
Yes.
And the needs of this honorable court. If you're unlikely then the court admits, agrees, and admits, we seek the leave of your lordship to address things that we will attach to the document and address. We are not of that.
Yes.
Yes, another, first and foremost, that document falls under the pleadings of paragraph 22 of our statement of our amended complaint, paragraph 22. With your permission, my lord, I can read it.
Yes.
The claimant pleads and shall rely on any document or documents not herein expressly pleaded that shall be relevant to his case during the trial of this case.
That is a big.
Please, can I address the court, please? I am responding to what you said. You raised the preliminary objection, and I'm addressing it. You have raised the preliminary objection. Allow me to address it.
I did not interrupt you, so please.
I apologize.
My lord, his clients are watching, so he has to do his work. My lord, I pleaded it in paragraph 22.
Yes.
And then in the list of documents that accompanies the complaint, the list of documents, it is number 4. Any other relevant document. My lord, on the issue of ambushing the defendants, I have not. That's the second issue he raised. I have not. Because the second defendant, the witness has identified the document as her document.
The mere fact that she identified it doesn't make it to be admissible. Doesn't make it admissible. The mere fact that she said yes, she has.
My lord, we are tendering it because it is her document and it has become relevant to the suit.
Relevant as how?
My lord, as we proceed, my lord will see the relevance. That's why I am very particular about the date.
Yes.
As we proceed, my lord will see the relevance of the document. My lord, apart from admitting that it is her document, it is relevant to our case. It will assist the court to determine this matter fairly. It will assist the court. My lord, relevancy is key in admissibility.
What is the relevancy of the document? You have not told me.
Okay, my lord, the relevancy is that the defendants, the second and third defendants who acted as the directors that employed me had sold the company to the fourth defendant on the 5th day of August, meaning that they were divested of every right and power. Yet on the 8th day of August, they issued the termination letter. Sorry, sir, on the 7th day of August, after being divested of their powers, on the 5th, on the 7th, they issued the termination letter. That is where we are going to. We want to show the court that with this document they signed, They were divested of every power as directors. So they wouldn't have any right to issue any termination letter as far as high quality is concerned. My Lord, that's the relevance, and it is key to our case.
Yes.
My Lord, furthermore, having admitted it is her document, my Lord, we have the right to tender the photocopy of the document because the original is in her possession. The original is in her possession. My Lord, we rely on the Section 12, Sub 2 of the National Industrial Code Law. Oh, sorry, National Industrial Code Act. That empowers my Lord not to be bound by the Evidence Act, but to depart from it in the interest of justice.
But that section only relates to admitting the document, but it does not go to
what that section says.
Attached with the document.
Now, what that section says is that he is raising the issue of not laying a proper foundation. Now, actually, I was to tell the court so that the original is in the possession of the owner. Yes, sir. But my Lord,
you are not the one to tell me.
Sorry, sir.
You are not the one to say that. Foundation is laid by the witness through whom you want to tender the document, not by you.
Yes, sir. My Lord, that's why I say with that omission and with what I have said in the interest of justice, I am referring, my Lord, to Section 12.
I have recorded that. Let's make progress.
Yes, sir. My Lord, with this, I urge you, my Lord, to admit that document. Admit the document so that it will enable the court to do justice to this case. Thank you, my Lord.
I hope you know the position of the law concerning changing ownership of maybe a company regarding the employment of its staff.
And my Lord, when we get there, we'll address the court. We'll address the court, sir. My Lord can see that the witness acknowledged the document, but was evading the issue of date. She said she can't see it, the document she has in her possession.
Fellow, if I may, sir.
Yes.
If I think with utmost respect, the claimant is attempting to record of this. So the extent that
Mr. Oyoma, I'm writing my ruling, so I don't want to hear anything like that.
having listened attentively to the submissions of counsel for and against the admissibility of the documents sought to be tendered through DW1A, it is clear to me that the documents sought to be tendered in evidence is relevant to the proceedings before the court. In the circumstances, and having regard to the fact that it is tried law that admissibility is paramount consideration whenever it comes to the issue of admissibility of document that is in issue, the said document having been found to be admissible in evidence is hereby admitted and marked as Exhibit DW1A. However, the weight to be attached to the said document is a matter for consideration when the court is writing its judgment. Parties in this matter are free to address the court on the issue of the weight to be attached to the document in their final written addresses. Yes.
Yes.
Yes, Mr.
Okay. Now, yes, my lord.
Yes.
Witness, when you sold the first defendant to the fourth defendant, you confirmed in paragraph 6G of your witness deposition that the second and third defendants had relinquished every interest in the first defendant. That's what you say, that's correct.
Yeah, I don't have it in front of me, but if that's what you say, it says, yes, I don't have it in front of me.
You don't have in front of you what you adopted and you are relying on. Now, I put it this way to you. When you sold high quality, that's the first defendant, you had relinquished every interest in it to the fourth defendant. That's correct.
Yes, I presume that's correct.
It seems that is correct.
I'm not sure what day we resigned as directors. I have to consult my records.
Yes, it would be.
Yes.
Yes, now, I have exhibit B in front of me to show to you. That is the termination letter. When you wrote the termination letter here on the 7th day of August. The 7th day of August to me.
Is there any dispute concerning that?
No, my lord, just to...
I said, is there any dispute? Have they denied it?
Okay, my lord, I leave it.
Something that is not in dispute, you don't need to.
As the court
please. Terminating your appointment.
As the court please.
If facts have been admitted, you don't need to prove it.
As the court pleases.
So goes to the issues that you need to credit the witness, not issues that are already tried, that all the parties have agreed on them. Yes?
Yes. Apart from Exhibit A, which is the service agreement that you entered with the claimant, there was no other agreement. That's correct. There was no other agreement between high quality. Now, this is the question. You had entered into an agreement, the one you call service agreement, company secretary to legal advisor. That is me, with high quality.
Yes.
Yes.
Which exhibit is it?
My lord, I showed her exhibit B, exhibit A, my lord, and she confirmed there was no other agreement except exhibit A.
I believe there's no other agreement. I can't see the documents he's holding up. I can't see what they are.
Don't worry yourself.
Okay.
Yes. My Lord, now I refer you to Exhibit B, the termination letter. In Exhibit B, your termination letter, which is before the court, you made reference to Article 6 and 7, notice of termination and salary. Article 6 and 7, which is not contained in Exhibit B. Sorry, which is not contained in Exhibit A, our agreement. That is true.
I don't have the documents of the details at hand, so I can't see. Maybe if the court can look.
What are you saying? Read the letter of termination. Read the letter of termination.
Okay. This is the letter of termination that you wrote, and this is the Article 6 and 7, which you referred to.
Read the letter, the whole letter, not just one part. Read the whole letter.
7th August 2020. Dear Barrister Manga, we hereby now formally terminate your employment on this day, 7th August 2020, giving you one month's pay in lieu of notice, as arranged in clauses 6 and 7 of your contract, namely 6, notice of termination. At any time after completion of the 3 months probationary period referred to in clause 5, either party hereto may terminate the employee's employment with the company by giving to the other party not less than 1 month's notice in writing or payment of basic salary in lieu thereof. Now, Article 7. The employee's basic salary at the commencement of his employment shall be 800,000 naira per annum. The employee's basic salary, together with any overtime remuneration, shall be paid monthly in arrears by transfer to the employee's bank account, details of which have been notified by him to the company on the last working day in Nigeria of each month. The salary will be paid in 10 amounts of 80,000 across the year for 10 months of the year. That is what is contained in the termination letter.
Okay.
Is that correct?
As I say, I presume it's correct. I don't have any of these documents in front of me right now. But if the court says it's correct.
Now, my question is, those paragraphs that you referred to terminate me, they are not contained in the agreement which we have here as Exhibit A between me and you. The service agreement, they are not contained here. You did not refer, those paragraphs are not from here. That is correct.
I'll have to consult the documents. I don't have them in front of me, but if the court can see on my behalf, I don't know how this works.
All right, the court will see it on your behalf.
What he is asking you is that you made mention of some clauses in the letter of termination, and those clauses you mentioned are not in the service agreement. Where are they? From where did you get them?
I'll have to consult. Sorry. I'll have to consult my documents and our records to find out exactly. I cannot say off the top of my head. I have to consult.
Are you your documents now?
I don't have them all here. No.
You don't have a letter of termination
back in our records and consult the exact wording of the original agreement.
Okay. Yes. Any other question?
Yes, my lord. But my lord, I don't know what is recorded in respect of this question that I asked her.
He says she does not have her document to cross-check to find out whether about that clause. If it's not there, it's not there now.
My lord, we will rely on the court, as she said during address.
You see, there is nothing you rely on the court. This is a contract of employment.
Yes,
it is the duty of the claimant to prove to the court that he is an employee of the employer, and it is the duty of the employee to also prove to the court the conditions of service. This is the business of the defendant to prove those things for you. As a claimant, it is your business You are the one that is saying the wrongly terminated. So it is your duty to prove that you are employed. It is your duty to show to the court this is the condition of service that govern my employment. And they have breached that condition, and this is the way they have breached it. Amadou versus Amode is very clear on this. Is the one that looks classical on this thing. It's a right to employment. There are even, I can say there are even thousands of cases to that effect. Decided one. It is the duty of the employee, not the duty of the employer. The employer does not have anything to do with proof of condition of service. See Kato versus CPN, it is there. See Iguilo. Next. Any other question?
Yes, my lord. My lord, I intend to show the witness exhibit A again.
Maybe we have to take adjournment. Let her get the letter, a copy of the letter. I don't want a situation whereby they will be saying she didn't have. Mr. Ohen.
Okay, my lord, let me.
We have to tell your client to have all the relevant documents concerning this with her.
No, my lord, I'm going to skip them. I'm going to skip those ones. They are contained in the document. I'll prove it later.
No, I don't want you to say we shut you out.
No, my lord. No, my lord. I'm okay.
Let her get the relevant document, the agreement, whatever. Let her have room with her when she's.
My lord, I am okay. I'm okay. I'm not referring to the documents again. I just have two questions to ask her.
Okay.
Yes, and I'm done.
Yes.
Now, the service fee payment to the claimant was 2 million naira per annum, paid quarterly at the rate of 500,000 naira per quarter. That is correct.
I don't have these exact details.
Is that correct? You were paying the claimant 2 million in a year, and you divided them into 500,000 per quarter. Is it correct or not?
I need to look at I don't have any of the figures in front of me. So when I can confirm if I have them in front of me. I don't know if my lawyer has any of the figures in front of him.
Yes.
If I may, because the question itself goes to.
Mr. Yama, you don't need to say anything. Mr. Manga.
My lord.
Is there any dispute concerning your salary?
My lord, I want none, but I wanted
that your salary is 2 million.
My lord, there's none. I wanted that to confirm. Is there
any dispute that is to pay you quarterly?
There's
none.
Have
they not paid you before?
They have been paying.
Have you not tendered evidence to that effect?
No, my lord, the evidence of payment is not there because they didn't dispute it. That's why I didn't bother to bring evidence, but I wanted that to confirm. Now that she is not confirming, my lord, I think I should be done.
I can't. I need to see the
my lord,
actual.
I'm done.
Okay.
I need to see the actual figures, or if my lawyer can confirm the figures. I'm just charging my battery.
Wait. Let her get the.
Excuse me, just charging my battery.
Have you gotten the document? It's Isabel, he said he has finished asking you questions. Mr. Oyoma,
my lord.
Yes, no examination.
My lord, if you can hear me, my lord.
Yes.
My lord, I'm very sorry for coming in late. I had a small upset while trying to join the Zoom service. I represent the first and the fourth defendant. My name is Udogadi Yu. I just have one question to ask the witness.
Yes.
Just one question for clarification.
Listen to the counsel for the first and fourth defendant.
Please kindly confirm.
Yes.
I doubt the first defendant counsel, the first and fourth defendant counsel have a right first examine.
Why would you
have today?
The party.
However, as of today, the first and fourth defendant have not joined any issues in this.
But I was for the examine.
They have not filed a single process.
That doesn't mean that they cannot be allowed to cross-examine.
No problem. I thought I should give the attention of.
Yes, Mr. Udogadi.
Yes, my lord. Thank you, my lord. Please, can you confirm the agreement you entered between yourselves through High Quality Bakery during the sale of High Quality Bakery? Who did you enter the agreement with? Who did you enter the agreement with?
Could you clarify the question? Do you mean who did we sell the bakery to?
The question is, who did you sell High Quality Bakery to?
I haven't got the documents in front of me, but is it Benji's? I haven't got I don't know if our lawyer has the documents in front to confirm. I haven't got the exact name in front. I haven't got the.
It is not Engineer Ben Akak.
I think it was to a company, and I haven't got the correct name in front of me.
Mr. Udogadi, I did not get that question. Is it
my question is? My question is.
Wait, listen to me first. Is the question is it that to whom she sold the bakery to, or is it she enter agreement for the services of the claimant?
No, who he sold the bakery to?
I don't have the exact name in front of me. I think it might be Benji's something. I don't know if my lawyer has the papers with him and he could confirm the name there.
Okay. That would just be all.
Yes, you say no cross-examination.
No examination. We most humbly advise that the witness is discharged.
DW discharge. Any other witness?
No, my lord, that is the case for the second and third defendants.
Yes, thank you very much, Isabel, and the other persons that the lawyers have finished asking you questions, and they say that is the case you are putting forward before court. So if you are free to exit from the virtual sitting, if you so wish.
Thank you, my lord.
Yeah, excuse me, my lord. I'm free to leave the meeting.
Yes, you are free to leave.
Okay.
Thank you, my lord.
Yes, thank you. Please, can I just thank you? I feel you've presided very well. Very impressed.
Welcome.
Thank you so much. Thank you.
You are welcome. Yes, Mr. Udogadi.
Yes, my lord. At this point, I want to passionately. I came in from Port Harcourt as at day before yesterday night, and I was actually briefed not too long. I had already finished preparations to file a formal statement of defense and file the necessary processes. So I would want to crave my Lord's indulgence to please assist me with a request, just an adjournment, because I had.
Where's Mr. Udogadi?
Yes, my Lord.
All these days, when this matter was filed back as 8th of September 2020, and you did not have time to file your defense. And now you are
my Lord,
postponed the hearing and you are ready.
My Lord, I'm so sorry. In view of the fact that I had actually, when I met the claimant formally, I had actually did make some proposals to him, but that's notwithstanding. I had also expected that he's our colleague, and I believe that whatever had transpired, we as colleagues have the onerous responsibility to be able to see what is right and help each other, no matter how it is. But however, I'm only just saying that this is just one application that I'm going to make, and it won't repeat itself. I say it with all kinds of sincerity of purpose, just with a view to ensuring that the opportunity is given to the first defendant, especially, to be able to put in the little defense that she has, whichever way my Lord is bound to give a ruling. But I would just want to plead that my Lord accede to my request. This is not done out of disrespect to this honorable court. I don't intend to do that for any way. So please, my Lord, it's my humble request.
Give me. With the closure of the case for the second and third defendant, and in the absence of any defense filed by the first and second defendant, parties are hereby ordered to file their final written addresses in line with 45 of the rules of this court. This case is hereby adjourned to 11th of October 2022 for adoption of final written addresses.
As the court pleases.
I said in line with the rules of court. The rules of court says that you file together with what do you call it? With the soft copy. The hard copy should be filed together with a soft copy. To give you what? And that one, you do it with the registrar. The registrar will give you. You send it to the registrar. Yes. It's all right. You can send it to the registrar's email address. You made available your email address to them. Yes, Administrator, we have come to the end of this sitting. You can discontinue with the sitting.